I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you
rights.
are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go.
oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I lost my spot. Oh,
Well, no, it doesn't work that way.
okay, I'm not really understanding, but I am nervous, quite nervous.
Entitled Sovereign Citizen Squatter Karen shows up in court today over an alleged fraud case tied to $1 million house she refuses to leave. Right from the start, the plaintiff's attorney lays everything out, and honestly, it's worth paying attention because it exposes just how absurd her whole scheme really is. She's running the classic sovereign citizen script, rambling about rights and ownership like she cracked some secret code. But when you look at the paperwork, it's one of the sloppiest fraud cases you'll ever see. The confidence she walks into this courtroom with is almost comical when you compare it to the reality she's facing. What's wild is that squatters actually do get certain legal protections in some states, which is exactly why people like her try to squeeze through loopholes. But this situation isn't just squatting. This is straight-up fraud dressed up in sovereign citizen word salad. Let me know what you think. Do squatters deserve these protections? Or should the law change so cases like this never even make it this far? Let's get into it and watch.
Ian Redmond, P70599, on behalf of the plaintiff.
Your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the Federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year, and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
This case is blatant fraud, and the way she thought it would all play out tells you everything you need to know. From the outside, it looks like she pretended to be the Whitlows, took out a mortgage on $1 million home, defaulted on it, and then tried to hide behind bankruptcy as if she ever had a legal claim to begin with. The only problem is she's not even on the mortgage. That's like borrowing your neighbor's car, wrecking it, and then filing an insurance claim in their name. It makes zero sense, and it's obviously fraudulent. What really blows my mind is how she thought she could pull this off without leaving a massive paper trail. Mortgages and bankruptcy filings create records that stack up fast, and once investigators start connecting the dots, the fraud lights up like a neon sign. Judges don't just care about whether you said the right buzzwords. They care about whether you actually had a legal right in the first place. And here, she has absolutely nothing. She just keeps piling lie on top of lie, hoping to drown the system in nonsense paperwork. Do you think she even realizes how bad this looks on paper? Or is she so deep in the sovereign citizen mindset that she genuinely doesn't care? Because if she keeps pushing this, prison is very much on the table. Interview.
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any rights.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow,
you
who's
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to
I don't know what you need to do, but
Well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing. Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Okay, I'm not really understanding, but
She's doing next is one of the most common bankruptcy fraud tricks out there, and it's honestly shocking how transparent it is. Filing for bankruptcy triggers something called an automatic stay, which basically pauses all debt collection while the court reviews a case. That means creditors can't evict you, garnish wages, repossess property, or collect in any way during that period. People who know they don't actually qualify for bankruptcy relief still file anyway just to buy themselves time. It's like hitting a pause button and hoping the judge doesn't notice the filing is bogus. But courts see this move all the time, and when they catch on, it only makes things worse. At best, she bought herself a couple of weeks. At worst, she risked years behind bars for fraud. It's a gamble that might delay the inevitable, but it never fixes anything. Judges know exactly why people do this, which is why they come down so hard once the scam becomes obvious. Do you think she really believed this would work, or was she just desperate enough to try anything?
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case, and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay.
any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract, allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what, if the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you.
I know, you didn't write it.
We'll await. I did.
Oh,
No.
no, I don't think so.
She just walks out instead of even challenging the judge's order, says everything. Maybe she knows the Whitlows don't actually exist, or maybe she realizes pushing any further would only make things worse. I don't want to assume too much, but it really feels like there's more going on behind the scenes here. This isn't just squatting. It's entitlement mixed with fraud. The part that really got me was her complaining that $15,000 a month is too much, like she's negotiating rent instead of standing in front of a judge. That squatter playbook is always the same. They truly believe they're above accountability. And honestly, I kinda get why she thought she could keep getting away with it. She's been sitting in $1 million house and nobody stopped her for a long time. The uncomfortable truth is that people like this clog up the system with nonsense, waste everyone's time, and live in homes they don't even own. At some point, patience runs out and fraud charges become unavoidable. Let me know in the comments. Do you think this Karen squatter deserves prison time for this scheme, or should the system just focus on kicking her out and moving on?